I'm Cynthia Rowland, and this is episode 153 of EO Radio Show. In today's episode, I'm focusing on the legal principles that fiscal sponsor organizations need to know. These sponsor organizations typically are charities described in Internal Revenue Code Section 501c3. I include in this discussion the practical implications of sponsoring projects as well as the legal issues that can arise. In this episode, I'm going to go over the terms sponsored project and fiscal sponsor, what they reference, and the legal context within which they operate. In episode 152, I covered much of the same ground, but from the sponsored project's perspective, that is, the perspective of the founder that's thinking about using a fiscal sponsor arrangement. So right after this episode was recorded, that is yesterday, Thursday, April 23rd, the Treasury Department announced that the IRS plans to revise the Form 990 to improve transparency, strengthen tax administration, and provide clearer reporting on certain activities of tax-exempt organizations. Now, interestingly, those areas include government contracts, government grants, and fiscal sponsorship arrangements. The Treasury and IRS expect to publish proposed regs and provide an opportunity for public comment before any reporting changes are finalized. But I wanted you all to know about it as you listen today to stay aware that the rules and the reporting and the practical implications may well change in the near future. I'll report in future episodes on these changes as they become public. But in this episode, I do touch on some recently introduced federal legislation known as the Sponsor Act and its potential impact on the nonprofit sector in connection with operating fiscally sponsored projects. So much to come in the future, but for today, most of what I'm going to talk about will be well known to fiscal sponsoring organizations that do this as part of their mission. What I want to focus on today are the things that are really important for newbie fiscal sponsorship organizations that want to do fiscal sponsorship either as a one-off for an activity that they want to bring under their tent, or for operating charities that want to dip their toe into the fiscal sponsorship waters because it seems like a good way to advance their mission by bringing on board other founders with similar ideas. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. So as a baseline, fiscal sponsorship means an arrangement where an existing 501c3 nonprofit corporation that has its exempt status under the Internal Revenue Code has agreed to sponsor another activity by accepting contributions supporting the charitable activity through a defined relationship with that project. So what does this mean for the sponsoring organization? The fiscal sponsor organization is not just a service provider to projects. It is the governance and finance and compliance and risk management function of the activity that is being sponsored. And this is because the sponsor is the legal entity holding itself out to the donors and to the public as a nonprofit charitable organization. This has implications not only with respect to the acknowledgement and offering of charitable contribution deductions for the donors that make contributions to the project, but it also has real meaning in relation to the attorneys general of the states where the fiscal sponsor organization is operating. To put it very bluntly, the sponsoring organization has a real legal risk and legal obligations for sponsored projects. That differs a little depending on which of the models, but fundamentally, that's the lens that we're reviewing this through, that the sponsoring organization is the legal entity with the liability. So the non-negotiable principle here is that the sponsoring organization cannot be a mere conduit for charitable contributions to go into a charity that for which a charitable contribution deduction is claimed and then is passed through to the project or as another party without meaningful control. The attraction of the fiscal sponsorship for the founder and its donors is typically the arrangement is marketed and the contributions are solicited on the basis that the donors get a deduction for contributions to the sponsor, and yet the funds are actually used by the founder in the founder's activity. The board of directors of the fiscal sponsor organization must understand that they hold the financial and reputational risk. Most often, they also have personnel and employment-related responsibilities for the sponsored project. And not only employees and personnel can create risk for a sponsoring organization, but so can the volunteers to the sponsored project. So let's talk about the three models of fiscal sponsorship that most often are considered by fiscal sponsor organizations. These three models are the direct project or internal program. The second one is an independent contractor type of project. And the third is a grantee relationship with an independent public charity. As a brief introduction, we often refer to these as models A, B, or C. These are labels that are widely used in the nonprofit practice literature. The original publication by Greg Colvin in 1993 coined these labels, along with a number of other types of arrangements that are often thought of as sponsored projects. And these have different messaging that goes out to the donors and to the constituents or beneficiaries of the project, and different core sponsor risk profiles. So in the direct project or internal program model, often referred to as Model A, what the sponsoring organization is saying and doing operationally is holding itself out to the world that this is our program. The sponsor operates the project as part of its own activities. It typically employs the employees and is the employer of record. It signs the contracts. It owns the bank accounts. It reports to the IRS and the state regulators on behalf of the project because, in fact, the project is simply an internal program of the sponsoring organization. Now, this has huge legal exposure, obviously, for the sponsoring organization because it has all of the contract and personal injury liability that the project may generate. And it also has organizational risk because if it is treated as a conduit, the organization can lose its exempt status and end up in hot water with the state regulators. Because if the organization says it's an internal project, but operates and allows the founder to operate as if it is external and autonomous, the sponsoring organization can have significant exposure in that kind of a scenario. The next model I want to talk about is the independent contractor project, often referred to as Model B. And in this kind of arrangement, what the sponsor is saying or doing operationally is holding out to the public that this is our program. We approve of it as a charitable activity, and we're carrying out the activity through an independent contractor. And that can be a very viable, appropriate way for a charity to achieve its exempt purposes. But it becomes a risky situation for the sponsoring organization if the contract terms are not sufficiently protective of the sponsoring organization. Risk management for the independent contractor arrangement is addressed almost entirely in the details of the service provider contract. The third type of arrangement is the pre-approved grant relationship, or the Model C fiscally sponsored project. And here the sponsoring organization is holding out to the world that the sponsoring organization is agreeing to fund a separate entity or project, actually a separate entity, as a grantee based on our typical form of grant agreement. The sponsoring organization receives contributions and then makes controlled disbursements and grants to the separate charitable organization based on deliverables, timelines, and all the other things that are in the grant agreement. So in this, conduit risk to the grantor can arise when the grant making is merely passed through without any diligence, with weak substantiation, limited or no monitoring of effectiveness, and donor messaging that treats the gifts as if they are made to the project simply through your organizations, you being the sponsoring, the fiscal sponsor, simply going through your bank account and taking a haircut for the overhead. So let's talk about in a little bit more detail the risk to the sponsoring organization in practice, how it differs between these three models. In the sponsored project, the internal project, the risks arise with fake internalization. That is, when there are governance and messaging failures. So the sponsoring organization that's considering a direct project activity as a sponsored project, they need to recognize that the biggest risk for this sponsoring organization in Model A arrangements with direct projects is that the sponsor may call the project an internal project and report on it that way, while in fact allowing project leadership and founders to act like an independent organization. So the red flag behaviors for the sponsoring organization to watch for are situations where the project leaders sign contracts in their own name, control bank access without sponsor control brands and intellectual property as if owned personally, or where these project leaders refuse to ask for or pay attention to sponsor approval requirements. In the Model B arrangement, where the activities of the sponsored project are carried out through an independent services agreement with independent contractors, the sponsoring organization can get lulled into a we outsource the work so we outsource the risk kind of mentality. That's often a mistake. Conduit risk and oversight expectations do not disappear because the work is performed by contractors. Any projects managed through a service agreement need to be managed through a carefully drafted services agreement, which includes all the typical provisions that you would see in an independent contractor arrangement. That is, clear expectations about insurance, indemnity obligations from the contracted party, and real and appropriate due diligence on the contractor's ability to carry out the activities for which they are being paid. In the pass-through grant-making model, or Model C fiscal sponsorship, to avoid conduit risk, the sponsor must be able to show it acted as an independent charitable funder. That is, it reviewed the purpose of the grants, it reviewed the conditions and the reporting, and was not simply acting as a forwarding agent. The sponsor's best protection against being treated as a mere conduit is to maintain a disciplined grant file. Like any other grant, the sponsored project needs to evidence its charitable activity and its worthiness for the grant and the installments by having a well-defined proposal, a clear budget, clear expectations about the milestones for releasing payments, clear expectations about timely reporting, and the sponsoring organization needs to have the ability to stop making the installments or to withhold installments if the grantee organization is not compliant with all of the terms of the grant agreement. So, as you might have inferred from all of the foregoing, the document architecture is really the important point for advising the fiscal sponsor organization. The written agreement must, or I should say, the documentation must match the model selected. So for the internal program, what is the documentation? Well, there's no contract because the fiscal sponsor is operating its own project and it doesn't need to have a contract with itself. So typically the terms of the arrangement are described in a memorandum of understanding, which is not a contract. And it should not have contract-like terms. It is a guideline and a list of expectations for the founder to understand how the project is going to be operated as an internal program of the fiscal sponsor. The sponsoring organization almost certainly will need a detailed project handbook or project manual that will cover all of the myriad things that the sponsoring organization needs to control in the arrangement. The MOU will have a clear statement that the project is a sponsored program and that it is not a separate legal entity. And in fact, often the MOUs prohibit the founder from also operating a standalone organization that's carrying out the activities because the opportunity for confusion if activities are carried out outside of the sponsored project is just unmanageable. The MOU will also say that the sponsoring organization retains ultimate authority over the project. And it will define either in the MOU or in the project handbook, it will define activities require sponsor approval, typically budget, hiring, contracting, public statements under the sponsor name, and many, many other details that may be relevant to the particular activities of a project. The MOU will summarize finance mechanisms. It will be clear that the sponsor is the organization that issues the receipts to donors. It's the sponsoring organization that signs grant agreements. It's the sponsoring organization that's responsible for internal accounting. All approvals for expenditures have to be reviewed by the sponsoring organization staff. The overhead allocation, I like to call it an overhead allocation as opposed to a fee because I think that drives home to people more clearly that they're not paying a sponsoring organization a fee for service. They are operating within the sponsoring organization and sharing in the overhead allocation. I think that's a really helpful distinction when people think about it that way. The MOU will also have a description about the expectations of the individuals that will carry out these operations, either paid staff as sponsor employees or potentially volunteers, and sometimes sponsor-approved contractors. All of those relationships with the individuals need to be managed and controlled by the sponsoring organization in the internal project model. It also needs to be clear in the MOU that no one other than the sponsors, officers, and staff people with delegated authority can bind the fiscal sponsor organization. The MOU will summarize ownership and control over the assets and how the sponsored project needs to keep the sponsoring organization updated about accounting for intellectual property, data management that the project may need to watch over, brand identity, brand trademark listing, things like that, and donor lists. All of those things are owned and should be controlled by the sponsoring organization. The sponsoring organization's MOU will also address in broad outlines the provisions for terminating a project and disposing of any remaining funds. Typically, the MOU makes it clear that the sponsoring organization can terminate the project on its own initiative at any time. And that is just a fundamental legal right of an organization that's operating activities. They can terminate it at will. Now, terminating employees will have to comply with employment laws. And so notices of significant layoffs and all that stuff, because that's on the sponsoring organization's watch, it should be mentioned in the MOU as the responsibility of the sponsoring organization and not of any project manager absent approval from the sponsor. Which reminds me a couple of other things that should be mentioned in the MOU, or at least in the project handbook, is that when the employees of a project are internal employees of the fiscal sponsor, all of the employee policies of the fiscal sponsor apply to all of the project as well. The sponsoring organization needs to be clear with each project that the state laws of all of the states where the sponsoring organization has employees will apply. So things like background checks, employee benefits, state laws regarding paid time off, all of that will be governed at the sponsoring organization level, not just on the local rules that might be required for the project if it were a standalone entity. It's not standing alone. It is part of the fiscal sponsor. I hope that didn't scare everyone off of using the direct project model, but it is not for the faint of heart or board members of a fiscal sponsor organization that don't understand the legal risks, because these projects can go sideways in a whole lot of different ways and create a great deal of headache for the board and the management of this fiscal sponsor organization. So if we move to Model B, the independent contractor arrangement, that one can manage the risk a little bit better because it is a third party that you're contracting with. While the sponsor is the donor-facing charity for soliciting contributions and grants, the project operations are managed under a defined services agreement with a contracting party for which the sponsoring organization has done its diligence. So the sponsoring organization will want that services agreement to be clear on the overall role of the sponsoring organization to get adequate reporting and deliverables from the independent contractor. Will have the right to inspect books and audit the activities of the contractor, and will require approvals for certain activities, but the sponsoring organization is clearly not managing and controlling the activities of an independent contractor. That's the whole point of a services agreement that's intended to be a contract like this, is that the responsibilities for the carrying out the actual activities are held by the contractor, not by the charity. So things like permits for an activity, safety, compliance, event management, employee, subcontractors, insurance, all of that is the responsibility of the contracted party, not the fiscal sponsor. The services agreement also needs to be clear on who signs what agreements. Typically, you would want the contracting party to hire all the subcontractors and be responsible for the diligence on all of that activity. You'll want the contract to be clear that neither of the parties is an agent for the other. You may want to reserve in the services agreement that sponsor approval is required for certain public-facing fundraising language. The final thing that's important to remember in this services contract for the Model B fiscal sponsorship is that the contract should include strong and clear term and termination provisions. the sponsoring organization will need to be able to terminate the contract on relatively short notice if it determines that it doesn't want to be involved in the project any longer. Since it's the sponsoring organization's activity for which the contractor is providing services, it makes sense that it would be entirely the sponsoring organization's purview to decide when it doesn't want to do the activity any longer. Next up is a quick discussion of the Model C, where you've got your fiscal sponsor organization is engaging with the sponsored activity through a grant agreement. We're really just looking at a clear and generally customary grant agreement. So the separate parties are the fiscal sponsor as the grantor and another independent nonprofit organization, which may or may not have its tax-exempt status yet, but it is a corporation that is separately incorporated and would be a nonprofit, would be an exempt organization for the grant style to make sense. So following grant-making protocols, you would expect to see a proposal from the grantee along with a clear budget, a description of the disbursement process that is expected, and the permissible charitable uses. The grant agreement should include reporting and monitoring requirements that the grantor fiscal sponsor can enforce. The sponsor should have discretion and control over the distribution of installments on that grant, and it should be able to have appropriate remedies for identified misuse or concern about misuse of the grant funds. A good way to frame the grant agreements is to go back to concepts of expenditure responsibility. I'll list in the show notes several episodes of the show that address expenditure responsibility as well as typical terms that I like to see in grant agreements. All of those things are just as relevant in the context of a Model C grant-style fiscal sponsorship as with any other grant arrangement. The key difference, though, is that in the fiscally sponsored grant arrangement, the sponsored charity is the one that's doing the fundraising and reaching out to the public or foundations for funding that will go through the fiscally sponsored entity. So coming right back to my early remarks, the pressure point here is to be sure that the fiscal sponsor organization is not being treated as simply a conduit to launder the charitable contribution money or grant money from other organizations, and instead that the fiscal sponsor actually plays an active role in supervising and managing the subgrantee's use of the charitable contributions that it regrants to them. So the one last area that I want to touch on today is the Sponsor Act, which is newly introduced legislation in the United States Senate that could potentially affect fiscal sponsors in a pretty dramatic way. So what is the Sponsor Act? This act was introduced in February of 2026, and its long title is Stop Proxy Organizations Nurturing Subversive Operations and Riots Act. That is the Sponsor Act. It was introduced by Senator Cruz, and it has been referred to the Senate Finance Committee. So it's a ways away from being enacted, but it is bringing to the national stage for the first time what fiscal sponsorship is and why it needs to be regulated. I'm not saying it does, but having this act out there in discussion will almost certainly raise the profile of fiscal sponsorship, at least at the federal government level. So what is it and what will it do? The bill would amend Section 501 of the Internal Revenue Code and add a new provision, that is 501S, S as in Sam. And that's the provision is intended to impose the liability on fiscal sponsors for sponsored activities. Well, that sounds scary if I'm a fiscal sponsor. So what are the triggering concepts and why would it matter operationally to a fiscal sponsor organization? Proposed Section 501S1 would apply when a 501c3 spends funds for a fiscal sponsorship and either the Section 170 charitable contribution deduction is allowed to a donor, or the sponsor represents to a donor that the donor is entitled to a deduction for a contribution for purposes of the sponsorship. The point here for the fiscal sponsor organization is that this is the first appearance in Section 501 of the Internal Revenue Code of the concept that a fiscal sponsor organization will have some liability when it's sponsoring projects where the sponsoring organization has received tax-deductible gifts. So it's a very odd place in the federal law to put this kind of liability, but they had to, or they didn't have to, they chose to attach it to the organization's exempt status by creating a risk for the sponsoring organization if it's using charitable contributions to fund these impermissible activities. So what are those impermissible activities? Well, 501(s)(2) ties the liability that they're trying to impose in this act to a fiscal sponsor that's engaged in funding a covered activity. That is, covered activity is defined in the bill as an activity involving certain defined foreign terrorist organizations. So the point here is that this new provision is trying to penalize fiscal sponsors when they move money to activities that are terrorist in nature. But with that being said, it could be interpreted more broadly, and it does raise the concept of fiscal sponsorship, like I said, to the national stage. So the takeaway here is that many incubation arrangements, including Model A-style projects and Model B-style outsourced projects, could be within the radius and the scope of this new act if the project is not a separate nonprofit organization. Proposed Section 501(s)(4) creates a presumption that the fiscal sponsor is responsible for ensuring sponsored uses comply with all applicable laws, regulations, and tax obligations. Well, that's certainly true. It already is the law for sponsored internal projects because there's nobody else that's legally responsible for the charitable uses. So it kind of 501(s)(4) doesn't really say anything new that we don't already know, but it is tying it more to the exposure here is tied more to the activities that are involved foreign terrorist activities. The important thing to know here is that if this bill advances out of committee, it does increase and may effectively require that sponsors engage in much more diligence reporting and monitoring activities in light of the final language in the statute. It's easy to say, oh, this won't apply to the vast majority of fiscal sponsors because they're not involved in funding terrorists. That may be so, but it is going to cause some closer look by sponsoring organizations at how they diligence and manage their sponsored projects. So in closing, just to wrap all this up into some takeaway points for the sponsor organizations that are new to the fiscal sponsor world, the sponsor's core discipline should be the same across all three models. The organization should operate so that discretion and control is true in fact, not just in the template agreements, but also in the way that the sponsored projects are operated and supervised. The model choice is fundamentally a decision about how the sponsoring organization is exercising control. That is, internal governance under a Model A direct project, contract-driven oversight, as in the Model B independent contractor, or grant maker controls, that is, Model C. The sponsoring organization needs to be able to evidence that control when it matters. That is, it's going to be able to show that the control is real to the auditors. It needs to withstand regulator scrutiny. It needs to withstand disputes with donors or misunderstandings with donors. And it needs to be able to withstand any new statutory liability regimes, such as is suggested in the Sponsor Act. So with that, we've covered a lot of ground today. Take a look at the show notes for links to episodes addressing grant agreements in general. And with that, I'll leave you here. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.